Hello, I'm Charlie Shane. I am a Washington State lawyer. My main office is located on Bainbridge Island, but I practice all over the Puget Sound region, or my firm does. I wanted to talk today some more about mediation, kind of continuing what I was talking about yesterday. It's a warm day. I have my window open. You might hear some tweets in the background. That's all right. So what I want to talk about is in preparation for mediation. So when you go into mediation, you should go into it as if you're going into trial. You want to have all of the discovery done, which is discovery is basically you want to get all the financial information from the other party. There shouldn't be any hidden accounts or newly discovered accounts or things like that. You want to make sure that you've been thorough, that your attorney has been thorough, that you've looked at the discovery. You should be at least somewhat familiar with the accounts. Now, sometimes there might be a situation where one of the spouses handled the finances and the other spouse just kind of let him and wasn't all that familiar with what was going on. But either way, you should be looking at that information and figuring it out yourself. It's interesting when you start really diving into stuff and you start looking at transfers and seeing where did the money go and seeing how the money flows. I absolutely love doing that. It's super fun, and it's especially fun when I find accounts that weren't mentioned before, that the other party conveniently left out of their discovery answers. I love that. I live for that type of stuff. It's really fun. And as a client, you can do the same thing. I mean, it doesn't take a special talent to be looking through those answers. But when you go in, you want to be as thorough as possible. Now, I will say one of the great things about mediation as well is you might think you know everything about what's going on or the case, and the other side comes in with the same theory, and a lot of times you'll find out new stuff, or you'll listen to new theories of the case. It's a great time to talk with your lawyer and figure out, oh, okay, well, now we have this information. What kind of position should we be taking? Or should we be ceding on this point? Or are we going to have to go to trial on this? I mean, don't get me wrong, litigation actually for me is fun. But again, it's very expensive for the client to litigate. I don't care what lawyer you get. That lawyer is going to have to put a lot of time into preparing for litigation, and then you're basically having your lawyer spend possibly days. I've had one trial, I think it was the longest trial in Kitsap County for family law. It went like 22 days. And so it can go a long time. So you want to avoid that. It's very costly. But when you go in, you want to go in prepared. You want to have all that information ready to go. You want to know what accounts there are. You want to make sure you're not missing any statements. You want to know what the assets are, what the debts are. You want to know what all the retirement accounts are. Sometimes they may have a pension that they didn't talk about, or if they had been working for a particular company and they have a vested pension and then they moved on to the new company, they just kind of conveniently don't tell you about that. So that you can see different things too on the taxes, on the tax returns. You can see, assorted investment accounts that the parties have because they're getting dividends from them. So you just want to make sure that everything is there, that all the pieces of the puzzle are there. I always consider a marital estate a lot like a pie, and you're trying to figure out how to divide the pie up. You start with dividing it in half, but then given certain circumstances like disparity of income, maybe one of the parties is a stay-at-home spouse that had been raising the kids and maybe just recently started work and doesn't really have the experience to get a higher paying job yet. That spouse might be entitled to more of the pie. And it's not just more of the pie, but then you also talk about maintenance, spousal maintenance. You talk about child support. There's all kinds of things that you're going to be going in, but you want to try to have as much information as possible. And your attorney will be a lot better prepared with that information. Now, your attorney is going to prepare some sort of statement, a letter, a mediation memorandum, something to give the mediator. And what the purpose of that is, your attorney wants to give the mediator an overview of the case. I like to go in and just say, here are kind of the points of contention. This is why we believe this point of contention should be this way or that way. But for me, I don't like to go in super aggressive. There's a lot of lawyers that like to go in and they write, they try to, I think the idea is they're trying to scare the other side. Like, if you go against us, this is, the wrath of hell is coming down on you, and all this stuff's happening. And that's really not my tactic. My tactic is I don't want to do things to poke the bear. I want to try to come to an agreement. So I'm going to point out the differences and why we think they're differences. But I want to come to an agreement when I go to mediation. That's my goal for my client. I don't want to do anything that might potentially jeopardize that possibility. Everybody knows what happens if you fail at mediation, and that's you go to trial. I mean, that's just it. You might reach a settlement beyond that, but I'm doubtful. Occasionally it does happen. I will say that, especially if you're fairly close at mediation, but not close enough to come to an agreement. Sometimes after the parties have an opportunity to kind of stew over things, they will reach out and come to an agreement. It might be a little bit more give and take, but it does happen. And I think I've mentioned this previously, but I've had cases that will settle in the middle of a trial. So it does happen, but I wouldn't bank on that. I think especially if you're just diametrically opposed to each other and approaches to things, then you're going to, you're just going to be, you're going to be going to trial. I mean, that's just it. So the more information that you have going into mediation, the better off you're going to be. Like I said, your attorney's going to write this letter or memorandum. Your attorney's going to want to make sure that all those materials are available to the mediator to go over before mediation. I like to organize them, have them neatly organized, and then I transfer them via link to the arbitrator. It's a lot easier than doing a bunch of notebooks old school. And most of the arbitrators accept it that way as well. I've never had one say, no, I want a hard notebook. I might be reluctant to go with an arbitrator that doesn't want a hard notebook. But it hasn't been a problem so far. Or an arbitrator that does demand a hard notebook. Now, when you go to trial, you do have to, unfortunately, give them hard notebooks. It kind of depends on the county. I think King County, it's all electronic now. But Kitsap County, some of the other outlying counties, they want their notebooks and their hard copies. And then when you, like I mentioned previously, when you get into the mediation, it's a lot of back and forth. It can go a long time. But it's also a great learning experience, because no matter what, when you go through mediation, you are going to have a much better understanding of where the other side's coming from, for right or for wrong. I think prior to mediation, you kind of get that understanding, but you don't always. And you will, I guarantee you're going to have a much clearer picture and understanding. Oh, this is where they're coming from. Maybe it's an unreasonable position that's not supported by the law. But you'll know. You kind of get that idea if you've had some hearings beforehand, but if you really haven't had the hearings, or even if you have had the hearings, you might get a little picture, but not the overall picture. Or you might, perhaps the hearing was more focused on the children and less on some of the assets. In fact, most of the time it's not, there's not going to be major asset divisions before. There can be, but usually there won't be. So you go into it kind of not fully understanding the other side. So at a minimum, you're going to have that understanding after you come out of mediation, and that will be helpful going into trial because you understand what their perspective is, and you can better prepare for it at trial. So these are a few other things to consider going into mediation. Tomorrow, I think I will talk about arbitration and the mediation arbitration hybrid, which I've been using it lately. It saves clients a tremendous amount of costs and gives them the ability to resolve their case quickly and much less expensively. All right, until my next video, I hope you have a great evening or day or whenever you see this. All right, stay awesome.